Hello everyone, and welcome to the lecture recording covering chapter 1. So we're gonna talk about legal foundations and cover the learning objectives from this chapter. So we're starting with the first objective, namely distinguishing the importance of the law as a regulatory tool in society and business. Alright, so the starting point is to understand what law is. Okay, and key points here is that law is a regulatory tool. So as it says on page 3, law not only prescribes what people cannot do, but it also informs what they can do and what they must do. In Australia, of course, the law also plays a number of other roles, such as guaranteeing our freedoms and permitting free enterprise and providing a means to settle disputes peacefully. Now, one of the reasons, of course, that we study law as business students or even engineering students is the interface between these domains, between business, between engineering, between law. And you have a number of examples of such interface. Takeovers or mergers, for example, criminal investigations in relation to white-collar crimes, and we'll talk about these in some more detail later on. These are things like insider trading, as well as corporate collapses and investigation of such collapses. And in particular, there's a crime of fraud, whether it's investment or corporate fraud, and basically that brings in as well the regulatory tools under the law. So the law, in particular, when we talk about criminal law later on, you'll find that criminal law has the main objective of punishment, and fraud is considered a crime under the existing law in Australia. So that means that as someone who's a business graduate or even engineering graduate who works in a business environment, you have to be careful and aware of the dangers that could arise from working in a corporate environment. Let's quickly talk a little bit more about what law is. Okay, so we're still talking about the first objective, which is to distinguish the importance of the law as a regulatory tool in society and in business. So, what is the law? This is one definition, and it's not the only definition. And it says law is a set of rules developed over a long period of time. And what does it do? It regulates people's interactions, both with each other as individuals and as individuals interacting with government. Okay, and the key part of the definition is at the end, okay, that this set of rules is enforceable through sanction. Okay, so that's a distinguishing feature between the law and any other set of rules, for example, club rules or sport rules. These are enforced by the police. The law is enforced by the police, which is of course part of the state. So again, it's a set of rules developed over a long period of time, regulating people's interactions with each other, and that sets, so this is the other objective, standards of conduct between the individuals themselves, or between the individuals and the state or the government, and that are enforceable through sanction. So the second point there on the slide is that rules are not always law, because we said that there are certain rules that are not enforceable through sanctions. Alright. The second objective is to recognize and explain the characteristics of a legal system and the main sources of Australian law. So, starting on page 6 of your textbook, we find that there are a number of characteristics listed of a legal system. So 4 characteristics. The first being certainty. Okay. So the idea is that a legal system is required to provide certainty, so that people know what the laws are and what the outcomes of their actions are going to be. And the need for this certainty, okay, explains why parliaments are reluctant to pass retrospective laws. Retrospective laws meaning that they are laws that apply to things that happened before their passing. So if you pass the law in 2017, for example, then you'd say, I'm gonna make this law retrospective, so it applies to anything that happened since 2000. Okay. Why would there be reluctance to pass such laws? Because they have the effect of making your act, which was lawful at the time, say in the year 2000, okay, it makes it subsequently unlawful in the year 2017, okay, which of course produces uncertainty and unpredictability. So the key point there is that we require certainty, but we also require flexibility. So the law must be seen as responsive to what's happening in society. Okay. Examples in your textbook are how the law has responded to the rapid advancement of technology, or adjusted to changes in moral values within the community. Now these two characteristics are shown in red on this slide to highlight the point that they are opposed to each other. There's tension between these characteristics. There is tension between these characteristics. Namely, being able to provide certainty brings in rigidity into the system, so it reduces its flexibility. On the other hand, being able to have a flexible or an agile legal system means that your certainty is going to be reduced because the law is changing all the time. Other characteristics include fairness, and fairness of course brings the idea of justice into play. So you'll find that many schools are called legal schools are called the School of Law and Justice, like us here at USQ. So why would they call it the School of Law and Justice? Because there's difference between the law and justice. Okay? You'll find that there are some legal studies, for example, that are done that not necessarily talk about the legal system per se. Okay? It's a closely identified concept with the law, justice is, but it's not the same as justice. Okay? And you'll find a definition or a comment by Lord Denning, who was one of the greatest judges in England, about what justice is. So you can look at that on page 7. The key point is that fairness and justice are not the same as the law, but they are part of the characteristics that we would like the legal system to have. So as society evolves, okay, we're hoping that our legal system will also evolve, and injustices of the black letter, as they call them, the black letter of the law, will gradually disappear and be replaced by fairness. Okay, so it is a long sort of process, evolutionary long-term process, but we're hoping that more and more fair and just laws will come into existence as this society of ours keeps evolving. And the fourth characteristic is basically accessibility. So everyone has access to the law, okay, and knows the law, okay. Accessibility is not necessarily the same as knowledge, okay. So understanding and knowledge are not the same thing as accessibility. Being able to access not necessarily means that you know what the law is. But here we talk really about basic understanding, okay, basic understanding of what the law is. So hopefully something that you will be able to master by successfully completing this course. And there are certain objectives given to you on page 7 under accessibility, and these are important for our purposes in this course. This is basically what is expected of you as a student taking the course. So it says there, the only outcomes, okay, that we want hopefully to achieve by you taking the course are the following. You need to be able to identify a legal issue, okay, determine what area of law may apply, know where to find information about the relevant area of law, understand the relevant elements of legislation or a case, and be able to understand and interpret what was read, and finally apply the relevant legal rules to the facts. Okay. So in our course, we're not going to just help you understand accessibility to the legal system, but we still also need to be able to get you to have this overarching objective of the course, and that basically is what we have just talked about, of being able to identify the legal issue all the way to applying the relevant legal rules to the facts. And the reason for that is that this understanding that you will get from this course will hopefully reduce the possibility of serious legal issues arising in your business career. But if they do arise anyway, okay, your understanding of this basic structure of legal analysis will hopefully result in dealing with the problem in a more timely manner and produce a better result. Some of you might have already heard about this approach, which we usually refer to as ILAC, i.e. the issue, the relevant law, and application of the law, and the conclusion, ILAC. So the first letter I stands for issue or the legal issue, second L for law or relevant law, the A is for the application of that law to the facts, and finally the C for conclusion. And that's what you will be doing mostly in part B of your final exam, but also for your assignment. Although in the assignment it's going to be a much condensed and reduced version, so it's going to be pretty much like writing an essay. Alright. So let's move on under the second objective always. And to remind ourselves, we're talking about the objective to recognize and explain the characteristics of a legal system and the main sources of Australian law. So we are moving now to the second part of the objective in relation to the main sources of law in Australia. And the main sources are two. As you can see on the slide and on page 8 of your textbook, you have common law and you have statutory or statute law and its delegated legislation. Okay. Common law is basically law created through the reported decisions of judges. Okay. Sometimes it's also referred to as case law or precedent or even unwritten law. The other type, the other source, is what we call statute law. Okay. And this is the law that comes from Parliament. Okay, so this is the law made basically by federal and state parliaments. And if you recall, we have of course federal parliament and we have state parliaments. So both of these bodies are able to create statute law and then delegate some of the lawmaking responsibility or function to lower bodies that create what's known as legislation, as regulation rather. All right. Now we also want to classify common law in a different sense. So in this classification we can talk about common law as distinguished from other legal systems. Okay. And the other legal systems, for example, can be seen in the in brief box on page 10. Alright, so you can compare the common law with other legal systems as shown on page 10. Things, for example, as civil law, which is what's known as an inquisitorial legal system, as opposed to common law, which is an accusatorial legal system. So inquisitorial basically gives more power to the judges, in the sense that they are the ones who run the inquisition in relation to what occurred and who was right and who was wrong, as opposed to common law accusatorial system, where the parties themselves, or to be more specific, their representatives, their legal representatives, their lawyers, are the ones who actually are controlling the process of finding the truth. Okay. So the judges in accusatorial systems are simply playing the role of an umpire. They are not actively involved in seeking to formulate arguments or discovering evidence to explain basically what went on and finally decide for one of the two parties. You find also legal systems such as what's known as the Sino-Soviet legal system. So again, the emphasis on codes, which is what we find in civil law systems such as those found in Europe, most importantly in France and Germany, but also in many parts of Asia such as France and also in Latin America. So the Sino-Soviet legal system is pretty much a variant of civil law. You also find things like Sharia or Islamic law and Hindu law, and also the Talmudic or Jewish basically legal system or halakha, and all of these systems are inspired in one way or another by religions, and they basically interpret the texts of those religions and use them as sources, okay, as sources for the legal system under that religion. The common law, on the other hand, has, as we said, two sources, two main sources. It's either the case law made by judges or the statutory law made by parliaments, and of course parliaments in a democratic system are nothing more than the representatives of society. So the laws under common law are really made by, or rather the sources of law in Australia are really sources coming through from society itself, rather than, for example, from a religion compared to the Islamic or the Hindu or the Talmudic legal systems. Alright. Then we also can talk of common law as opposed to equity. Okay. And equity basically is something we'll talk about in some more detail later on, but it's another legal system that emerged since the 12th century in England because of difficulties bringing about new causes of action under the existing legal system back then. Okay. So the case law in the courts became too slow, too complex, and people decided to go directly to the king, and the king later on delegated that to clergymen. That eventually, of course, was integrated again with the mainstream legal system under what's known as the Judicature Acts. But the idea again is that it started something different, and that's a good point to keep in mind when we discuss later on what's known as alternative dispute resolution methods, and the emergence of these methods as a response as well to the ossification or the rigidity of our legal system as we see it today. All right. So we said that we have the common law and the statute law as our main sources. Key point to remember is that when there's a conflict, okay, as it says on page 8, when there's a conflict between these two sources, is statute law. Okay, that's the most important source. It overrules common law in the event of a clash, and the rationale for that is quite simple. You find that statute law comes from representatives that were elected by society, while common law comes from judges that are simply appointed. So because we are a democratic society, what trumps basically is statute law, because those are the laws that we elected people to enact for us, so they are more representative of what society wants, rather than the law that is basically a gloss or interpretation of these statutes that comes or might come from the courts and is made by appointed judges, not by a democratically elected representative. Moving on then to our third objective, which asks us to identify characteristics again of different legal systems and define civil and criminal law under the common law system. We have touched upon already the characteristics of different legal systems, as we said on page 10, in relation, for example, to civil law, common law, or the other Sino-Soviet and the religious Islamic or Hindu or Talmudic systems. But we still want to clarify the difference between civil and criminal law. Here is another classification that talks about things like international law versus municipal law. So international law is the law made by international or supranational organizations, for example like the United Nations, which sometimes could pass through binding agreements or treaties, as opposed to municipal law, where the municipal law comes basically from your parliament or from your elected representatives. Okay. So the difference between them, of course, is that international law would not be binding on Australia, for example, unless and until we pass our own municipal legislation. So municipal legislation is basically like statute legislation, but it's passed in our country. So municipal really distinguishes between different jurisdictions. So if it's passed in Australia, it becomes a municipal law, and we can incorporate whatever treaties or conventions that we have signed through international instruments into our legal system here in Australia, and that becomes binding law in Australia. So that's one classification. You can also think of another classification in relation to public versus private law. Public law is, again, back to the definition at the beginning of this lecture. Public law is where you have an interaction between the individual and the government. So if there is something that you are contesting or taking a cause of action about something that has to do with government, so you are suing basically the government, or the government is suing you, then that would be public law. Okay, so if you sue the government, it would be something like, for example, administrative law. If they are suing you, it would be more something like criminal law. Private law, on the other hand, looks at the interaction between individuals. So things like contracts, for example, even torts. Because the parties to this cause of action, the parties to the lawsuit are basically individuals. Alright. When we say individuals, of course, we mean individuals in the sense of legal persons, which could include companies, but we'll talk about that in some more detail later on. Now, we also have a distinction between substantive law and procedural law. And substantive law talks about the doctrines and principles and rules of substantive areas. So substantive means it's a coherent area of law that is basically usually studied as an independent part of the legal system. Things like contract law or tort law or constitutional law and so on. Procedure, on the other hand, are the rules that govern how you bring a cause of action. So every court system or every court has its own, or every level of court has its own laws or rules, if you like, procedural rules of how, for example, to file a statement of claim. How much do you have to pay for that? What happens if you want to withdraw it? Or how do you provide evidence? Or how do you file affidavits? And so on and so forth. So the procedural rules are for litigation. If you want to go to court, you need to know what or how you can move these kind of documents of cause of action within the legal system, within the court system. They have nothing to do with the legal arguments that will have to be presented when you actually stand in front of the judge and present your case. Okay, so that's the difference between substantive and procedural. Procedural relates to the process of bringing in the cause of action, and the substantive talks about the substance of what will be discussed or what will be argued. And the last distinction is common law systems versus civil law systems, where you'll find this is very much what we talked about on page 10 in our in brief box in relation to the difference between civil law and common law countries. Alright. Here is another detail on what we discussed in relation to public and private. It gives you more examples. For example, you'll find public is things like administrative law and criminal law. There's also constitutional law or taxation and industrial law. Private law, on the other hand, talks about things like contract law, tort law, business entities law, succession, negotiable instruments. We're not going to cover all of this, but we're going to cover most of that. The distinction again is that when you have public law, you are dealing with the government. When you have private law, you are dealing with individuals. Alright, let's then finish off the chapter with the fourth objective, that's discuss the foundation and application of common law, equity and statute law in Australia. So as we said at the beginning, common law started from the 12th century and went through to the point where it became ossified on the 15th or 16th century. So it started really as customary law. Okay, it was the local customs where you found judges going through a circuit. They call it a circuit. So basically they go around the country and they sit in every town and they adjudicate for the people. But as they have done this century upon century, century after century, eventually these customs again became uniform. Okay, so the differences between the towns, the differences between regions melted into a uniform code, basically, that we know today as the common law. Not code in the sense that it was passed by parliaments, but code in the sense that it was codified to eliminate the differences between the towns and the differences between the regions. And this is how the doctrine of precedent came about. Of course, the doctrine of precedent means that like cases should be decided alike. So when these judges were deciding cases for people, if the facts in front of them are similar to something that they have decided previously, then the expectation is that that case will be decided similar to the case before it. Okay, so that's why we call it the doctrine of precedent. Now this is, of course, if the precedent is binding, and we'll talk a bit more about that in due course. The key point here is that it's a doctrine, so we need to understand that the word doctrine, and you can look it up as well in any legal dictionary, such as the Australian Legal Dictionary, which is available for you at the library for free. A doctrine is nothing more than a precedent. Okay, the precedents over time, as this case or similar cases are decided, it becomes formulated into a doctrine. So the law that came out of that becomes a doctrine, was known as a doctrine, and it becomes something that's applied to later cases, provided, of course, that you don't distinguish between the case that you are looking at and these previous cases. A principle, on the other hand, when we talk about a legal principle, is related more to legal theory. So it has not much to do with case law or law made by judges or the precedent doctrine. It's more about theory, okay, such as, for example, the principle of subsidiarity, something that comes from constitutional law. It's still more a theory because its application hasn't really become it hasn't evolved enough over time, so, and its application in our court system, so that we can refer to it as a doctrine. It hasn't been developed further by the courts to the point that we could call it a doctrine. Okay, but doctrines are based on principles, so they start in the sense as a legal theory, and they become adapted and adopted by the courts, and hence over time they are referred to as doctrines. Rules, on the other hand, are the simplest of these. So rules are applicable only to a small area, such as, for example, traffic rules, and that's why we specify them as rules as opposed to principles, which apply to a very large area of the legal system, and the same thing for doctrines. Now, the idea of precedent requires something in relation to reporting, because you cannot refer to this previous doctrine or previous body of case law unless it's reported. And historically, there were reports only of the superior courts, we call them, so the highest courts of the land, the appellate courts or the courts above that. But over time, and with the, of course, advent of the information revolution and the ability to have cheaper electronic reports, you'll find that there is more case law being reported these days. The key point is that without these reports, we wouldn't be able to give effect to this doctrine of precedent. The reports will report the law for us, and lawyers will basically summarize these reports and present them to advocate their arguments in relation to a certain proposition of law, and it's, of course, based on that the judge would then apply or accept to apply them as precedents and follow them in the existing case. So the Latin name, just in case you see it as well, is for this doctrine of precedent is called stare decisis, okay, et non quieta movere. Okay, so basically, in a sense, what we are saying is that like cases should be treated alike. So there will be more discussion of this point in later lectures, but let's go back to our fourth learning objective for today, which is the second part of that objective, the classification of laws into civil and criminal laws. And you'll find a discussion of this on page 13. So basically you'll find that civil laws talk about laws that are intended to compensate people, and the main substantive areas of civil law are tort and contract laws, while criminal law is about punishing. It's about punishing the accused or the wrongful party. And the main distinction between the two is that in civil law, you get, if you win in court, you will get a monetary compensation, but in order to get that, you'll have to prove the case against the defendant to a standard called the balance of probabilities. Okay, so your evidence should sway the judge to the balance of probabilities that the defendant is actually wrongful. And the balance of probabilities is basically anything really that is above 50%. So if you just can sway it your way above 50%, then your evidence is enough for you to prove the case against your defendant, and that means you will, or at least you're on your way to get your monetary compensation. And the main, again, areas or cause of action in civil law are torts and contracts. So tort law and civil liability, and of course breach of contract, where the rights and obligations are created by agreement. Criminal law, on the other hand, is where you will have the state or the crown or the government bringing the cause of action against the accused. Okay, because committing a crime is really something of an action or a wrong, not just towards the victim, but a wrong towards the society as a whole. And this, of course, is then punishable by either imprisonment or sometimes by fines. And because it is punishable by imprisonment and fines, not necessarily just by asking the other party to pay compensation, as it is the case in civil law, because it's a higher consequence or result from losing such a case, we require the Crown to bring this case or to bring evidence against the accused to a level or to a standard of proof higher than just what we call the balance of probabilities. So in civil law we have the balance of probabilities, but in criminal law we require the government to go beyond that, a higher standard of proof against the accused, and we call that on the beyond the reasonable doubt. Okay, so the key point to remember is that the standard of proof in criminal law, which is beyond reasonable doubt, is higher than the standard of proof in civil law, which is on the balance of probabilities. Okay. Now, under criminal law, you will also find something called civil penalties. Okay, and these are basically reserved for conduct that falls short of criminal behavior, but they are still penalties in the sense that they are punishing the person who committed the wrong, and because they are civil, however, they need to be proved. The evidence that you furnish should simply be to the standard of the balance of probabilities rather than the criminal standard of beyond reasonable doubt. Okay. You can also read about civil penalties if you want now. You can read about them on pages 504 and 562 of your textbook, and also on the in the online chapters, chapter 35 on page 975. Alright. Now, let's then go back and look at these major and minor now sources of law or types of law. So we are now on page 14 of your course reader or your textbook. And the major sources again are the common law and the statute law and equity. Okay. There are also minor sources, and these are given to us here as merchant law or customary law. And you can read about this in some more detail, for example, in relation to negotiable instruments on page 871 online, which is part of chapter 32. Again, we're not covering the chapters 35, chapter 32, but it's just for you to gain more understanding of what law, merchant or customary law means. And another, of course, minor source of law that developed in England is because of occupation was Roman law. So you'll find that common law also has in a way its origins in civil law, or at least it was influenced by Roman law due to the occupation of England by Romans. So in addition to the common law, equity and statute law, these two other sources are minor sources and had minor impact on business law in England. And later, of course, we will see why our story starts from English law rather than Australian law, and how Australian law eventually evolved and became a different really legal system from the English one. So that then brings us to the end of this lecture, and our next lecture will cover chapter 2. Chapter 2 will be, of course, on the origins of Australian law. We will go back and have a historical really look, the context, if you like, of the Australian legal system as it emerged or evolved from the 18th century. Thank you.